determined, once again, to ban assault weapons and high-capacity magazines.
Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
But at the crux of this is a bureaucrat making a unilateral decision to try to turn millions of Americans into felons.
The pistol brace also does not help the shooter load the pistol more quickly.
That a firearm equipped with the stabilizing brace was, quote, would not be subject to the National Firearms Act.
To propose regulations to ban all devices that turn illegal weapons into machine guns.
Breaking news. Actions have been taken by Governor Michelle Lujan Grisham regarding the Second Amendment right in Albuquerque and Bernalillo County, New Mexico. U.S. Supreme Court strikes down New York's proper cause concealed carry law. The U.S. Supreme Court ruled that a New York state law that demanded proper cause be shown before granting a license to carry a pistol outside of one's house was unconstitutional. Gun rights activists who had opposed New York's harsh rule, which makes it illegal to carry a hidden firearm without a license, won the case by a 6-3 vote, which is a significant victory.
That a firearm equipped with the stabilizing brace was, quote, would not be subject to the National Firearms Act.
To pass universal background checks. Eliminate gun manufacturers' immunity from liability.
It also constitutes the Supreme Court's largest increase in gun rights in more than 10 years and calls into question legislation in 8 other states and the District of Columbia that restricts concealed carry permits in ways comparable to New York's. The law, which has been in effect since 1911, was declared unconstitutional by the Supreme Court's 6 conservative judges. The majority opinion in the case, New York State Rifle and Pistol Association Inc. v. Bruin, was written by Justice Clarence Thomas. The statute was upheld by the 3 liberal judges on the court. Justice Stephen Breyer dissent from the decision in writing, because it prevents law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms as provided for the Second Amendment. Thomas claimed in his majority opinion that New York's law violated the Constitution's 14th Amendment, which guarantees citizens a right to equal protection under the law. The decision was made a few weeks after mass slings at a grocery store in Buffalo, New York, and an elementary school in Uvalde, Texas, revived a discussion over gun restrictions in the country.
It wasn't a fully automatic machine gun that was banned in 1986. It wasn't the bump stock.
Getting assault weapons, AR-15s, out of the hands of people who shouldn't have them.
Democratic political representatives swiftly denounced the choice, claiming it would endanger public safety. The decision, according to President Joe Biden, contravenes both common sense and the Constitution and should deeply trouble us all, and he expressed his deep disappointment in it. Biden urged governments to adopt common sense gun laws to make their citizens and communities safer from gun violence, citing the horrific attacks in Buffalo and Uvalde. According to Kathy Hochul, governor of New York, this decision isn't just careless, it's reprehensible. Because the federal government will not be sweeping laws to protect us, Hochul asserted, our state and our governors have a moral responsibility to do what we can and have laws that protect our citizens because of what's going on. The insanity of the gun culture has possessed everyone all the way up to the Supreme Court. Eric Adams, mayor of New York City, stated that this decision has made every single one of us less safe from gun violence. The New York State Rifle and Pistol Association and 2 of its members, Robert Nash and Brandon Koch, filed a lawsuit after their applications for concealed carry handgun permits for personal defense were denied.
That was the plea of parents who lost their children in Uvalde. I met with every one of them. Do something about gun violence.
The pistol brace also does not help the shooter load the pistol more quickly.
Richard McNally, a justice of the New York Supreme Court, decided that neither man had adequately established a need for self-defense to warrant carrying a weapon in public. The plaintiffs subsequently brought an appeal against that denial in a New York federal court. They argued that the state law controlling concealed carry licenses, which restricts their issuance to those with good moral character and proper cause to carry firearms outside the home, infringes upon the Second Amendment. The U.S. Second Court of Appeals upheld the decision of a federal judge in New York to dismiss the case. The case was then taken up by the U.S. Supreme Court. In his majority opinion, Thomas stated that the proper cause standard in New York, as it has been applied by state courts, was at odds with the history of firearm regulation in the nation. Supreme Court to review constitutionality of firearms ban in domestic violence restraining orders. The U.S. Supreme Court has announced its intention to consider the constitutionality of a federal law that prohibits individuals subject to domestic violence restraining orders from possessing firearms.
But at the crux of this is a bureaucrat making a unilateral decision to try to turn millions of Americans into felons.
That men and women in this country have the right to defend their own lives.
This decision sets the stage for a significant Second Amendment case in the court's upcoming term. The justices have agreed to hear the Justice Department's appeal of a prior decision that struck down the ban. This development follows last summer's landmark ruling in New York State Rifle and Pistol Association v. Bruen, which marked the most significant expansion of Second Amendment rights in a decade. The Bruen ruling, authored by Justice Clarence Thomas, altered the standard that lower courts use to evaluate the constitutionality of gun control laws. The conservative majority held that laws must align with the nation's historical context. As a result of this decision, the offense under which Rahimi was charged was declared unconstitutional in Louisiana, Texas, and Mississippi following the 5th U.S. Circuit Court of Appeals' decision to vacate its initial ruling in his case and align with the Supreme Court's verdict. Rahimi had petitioned the Supreme Court to refrain from intervening in his case, arguing that it was premature for the justices to get involved given that lower courts were still adapting to the new legal standard established by the Bruen decision. Numerous significant cases are currently awaiting resolution as lower courts assess firearm restrictions that had previously been upheld under immediate scrutiny and deference to legislative judgment in line with the Supreme Court's anticipated shift.
We read about them and we learn what went well and what didn't.
Responsible gun owners already support enhanced background checks for 18 to 21 years old, red flag law.
The Justice Department, however, opted to expedite the process, asserting that the law was both constitutional and essential for reducing violence. They argued that the government has a historical precedent to disarm individuals who pose a threat to the safety of others, and that Section 922G8 falls within this tradition. The department contended that the Fifth Circuit's contrary ruling misinterpreted Supreme Court precedents, contradicted decisions from other appellate courts, and posed significant risks to victims of domestic violence. This upcoming Supreme Court review is poised to have a profound impact on the intersection of domestic violence restraining orders and the Second Amendment rights, with potential implications of firearm restrictions nationwide. Supreme Court's new gun rights standards alters legal landscape for firearms law. Less than a year after the Supreme Court's landmark decision expanding gun rights, the new legal standard outlined by Justice Clarence Thomas in his majority opinion has changed the legal context for gun laws and raised doubts about the viability of gun control measures.
To propose regulations to ban all devices that turn legal weapons into machine guns.
We're outmanned, we're outstaffed. We do need responsible gun legislation.
That you said that all assault weapons should be banned. Is that a fair statement?
Judges are entrusted with determining whether the laws are consistent with the nation's historical tradition of firearm regulation as they're being put to the test in courtrooms from coast to coast, including those recently enacted in the state and long-standing federal limitations with broad support. After Bruen, there's been a lot of activity and uncertainty over the Second Amendment, according to Joseph Blocher, co-director of Duke University's Center for Firearms Law. The Supreme Court's new methodology, which instructs courts to evaluate the constitutionality of laws solely on the basis of whether they're in some ill-defined sense consistent with historical tradition, is the cause of the change, which is happening in a variety of ways. The government must prove that the measure is in line with the country's long history of gun restriction in order to meet the Supreme Court's new criteria of deciding whether gun regulations are constitutionally permissible. According to Thomas, we hold that the Constitution presumes to protect an individual's conduct when the plain text of the Second Amendment covers that conduct. The government may not merely assert that a regulation advances a significant interest in order to justify the regulation. Instead, the government must show that the regulation is in keeping with the nation's long history of gun control. The Illinois Governor J.B. Pritzker signed a bill into law last month that forbids the sale and distribution of assault weapons and high-capacity mags in the state. The decision, which overturned a New York handgun licensing law, prompted the governors of New York and New Jersey to enact new firearm restrictions.
Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
Ban assault weapons. Ban them again. Do it now. Enough. Do something.
However, a wave of lawsuits from gun rights groups and gun owners who claim the new regulations don't adhere to the Bruin judgment of the Supreme Court are quickly responding to the new demands. And as they navigated the new legal environment, federal judges cited the June decision in their own rulings, many of which prevented the enforcement of the gun laws. Historically, and up until June of last year, politics has been the biggest barrier to gun legislation for the vast majority of Americans. Gun restrictions aren't being passed in the first place, not because judges are aggressively overturning them, according to Blocher. Courts are playing a more active role since Bruin. However, even in the strictest interpretation of Bruin, there's still enough room to enact the sensible gun laws that the vast majority of Americans support. New York's new regulations, which were signed into law a few days after the Supreme Court's Second Amendment ruling, demand that applicants for concealed carry firearms exhibit good moral behavior and prohibit the use of firearms in some sensitive areas, including temples, bars, and public parks. The New York State Rifle and Pistol Association and 6 gun owners in New York challenged parts of the law, claiming it was unconstitutional. Using the guidelines provided in the Bruin judgment as a guide, a federal district court in Syracuse, New York, denied the application of certain parts of the legislation, but the Second Circuit upheld them.
Under the new rule, these firearm owners will be required to obtain special registration, surrender or destroy their brace.
I'm determined, once again, to ban assault weapons and high-capacity magazines.
The Supreme Court was urged to step in by the gun owners, but it denied, leaving the law in force while the case is still pending. Similar to New York's prohibitions, carrying a firearm in some sensitive locations such as public libraries, museums, taverns, and restaurants, as well as on private land, is illegal under New Jersey law. In response to legal challenges by gun owners and 4 gun organizations, the sensitive place regulations' enforcement was halted last month by a federal district court judge. The state may regulate conduct squarely protected by the Second Amendment only if supported by a historical tradition of firearm regulation, said U.S. District Judge Renee Bum. Here, the plaintiffs have demonstrated that the defendants will be enabled to provide any evidence of a prior history of firearm regulation to support the sections being contested. The Supreme Court's new legal standard threatens federal statutes that were passed before the ruling, even though the legal disputes in New Jersey and New York have included new legislation that were passed in reaction to the court's ruling. Legal challenges and uncertainty surround Supreme Court's gun rights standards. U.S. District Judge Joseph Goodwin dismissed the prosecution against a West Virginia man who was accused of illegally owning a handgun with a destroyed serial number in May after concluding that the legislation was unconstitutional. A firearm without a serial number in 1791 was certainly not considered dangerous or unusual compared to other firearms because serial numbers weren't required or even commonly used at that time. A 3-judge panel on the U.S. Court of Appeals for the Fifth Circuit said that in light of the Bruin ruling, a 30-year-old federal law that forbids someone under a domestic violence restraining order from possessing weapons is unconstitutional. Judge Corey Wilson for the panel stated, "The government fails to establish that the restriction of the Second Amendment right by the statute fits within our nation's historical tradition of firearm regulation. The law is an outlier that our ancestors would have never accepted," he added, quoting Thomas's viewpoint. Justice Department officials plan to appeal the decision, according to Attorney General Merrick Garland. It could request a new hearing before the whole Fifth Circuit or petition the Supreme Court to hear the case. According to Blocher of Duke Center for Firearms Law, restrictions like the domestic abuse firearms law are now seen as valid and even essential. You won't always find laws that directly disarm people for intimate partner violence in the founding era, he added. Legislators weren't very bothered with it, but it would be ludicrous to claim that we can't do it now just because women weren't given the legal protection they deserved then and now in 1791. Although there is bipartisan support for some gun control measures, such as so-called red flag laws that allow courts to issue temporary orders allowing law enforcement to seize firearms from people who are deemed to be a threat to themselves or others, the Bruen decision may open the door for legal challenges to those regulations as well.
Today and others prompting the governor to put a public health order in place taking aim at gun violence.
Gun deaths are the leading cause of death for children 1 to 19 in New Mexico.
According to Esther Sanchez Gomez, litigation director for the Giffords Law Center, district court judges have difficulty applying the Supreme Court's Bruen decision, particularly when determining whether a weapon regulation is consistent with the country's historical history. According to her, it invites district courts to become historians in ways that are not equipped to be, she told CBS News. Additionally, a thorough examination of the historical record is necessary, which is a laborious operation even for a professional, and district courts with busy dockets are not well suited to undertake that. When U.S. District Judge Carlton Reeves issued an order in October raising the possibility of appointing a historian to serve as a consulting expert in a case challenging the constitutionality of a federal law prohibiting felons from possessing firearms, the challenge for judges in applying the new so-called historian tradition test spilled into public view. This court lacks historical training. Despite their distinction, the Supreme Court's justices lack formal training in history. We lack the intellectual and methodological expertise that historians have, he remarked. Judges go through evidence in a different way than historians do when they examine sources and research methods. Furthermore, we lack expertise in the perspectives of white, well-off male landowners on the control of weapons in 1791. In the name of constitutional adjudication, however, we are now required to play historian. As many court battles over new state gun regulations are still in the early stages, judges have an urge to halt the enforcement of the laws while the cases are being heard. State and federal efforts to impose stronger gun limits are nonetheless dogged by their difficulties in applying the Supreme Court's new legal standard and recent rulings rejecting both new and old laws. Advocates for stricter gun control, though, argued that politicians shouldn't be deterred by the possibility of court disputes. According to Sanchez Gomez, legislators should be taking Justice Thomas at his word and comprehend that Bruen isn't a regulatory jacket. It feels like a game of negotiating with yourself at the cost of many lives to do nothing in the wake of violence out of fear that it could be questioned. We should discuss Bruen to better comprehend what it represents, but because it's still developing, it would be counterproductive. New Mexico governor issues temporary ban on public firearms carry amid gun violence concerns. Following a string of gun demises, including the slaying of an 11-year-old boy, Governor Michelle Lujan Grisham issued a historic executive order this week temporarily banning residents of Albuquerque and its surrounding suburbs from carrying firearms in public.
Either openly or concealed, within cities or counties.
Today and will be effective for 30 days unless it's renewed. The governor says she knows people will disagree with certain portion.
I can invoke additional powers. No constitutional right.
Prominent Republicans quickly criticized the measure, and law enforcement officials have warned that it may not be enforceable. The order's legality and enforceability have already come up against roadblocks, with Bernalillo County Sheriff John Allen warning that it challenges the foundation of our Constitution, and Albuquerque Police Chief Harold Medina declaring that the city's police department will not be responsible for doing so. The outcry was promptly pounced by Republican officials, including Florida Governor Ron DeSantis, a 2024 presidential candidate, who said, "Your Second Amendment rights shall not be infringed." In a post on the social media platform X, Representative Lauren Boebert also slammed the prohibition, calling it flawed and posing the question, if a governor felt like declaring an emergency right before an election, they'd be to suspend the 19th Amendment and stop women from voting. Open and concealed carry will be prohibited on public property for 30 days with certain exceptions, including for security guards and law enforcement officers, according to the prohibition, which is categorized as a public health order and went into effect immediately. Violators may face fines of up to $5,000. Open carry is illegal in 5 states, including California, Florida, Illinois, New Jersey, and New York, but legal in Connecticut, Hawaii, Maryland, Massachusetts, Minnesota, Rhode Island, and South Carolina with a permit. A prospective court case. Lujan Grisham stated that she anticipates a legal challenge and acknowledges that if one arises, she is unsure of its legitimacy. The order was the utmost recent effort in the state to reduce gun violence, and it was also the one with the most enforcement-related concerns. After a group of rural sheriffs opposed the legislation, claiming it violated their constitutional rights to due process and the right to bear arms, Lujan Grisham signed the so-called Red Flag Law in 2020, allowing state courts to temporarily seize firearms from people deemed to be dangerous to themselves or others. Lujan Grisham responded by requesting that any law enforcement official who chooses not to uphold the legislation resign. Big number. 493 is a big number. According to data from Gun Violence Archive, which keeps track of mass slayings in which 4 or more people are slayed or injured, there have been that many mass slayings in the United States this year. According to the GVA, more than 520 persons were slayed in the incident. Tangent. Data from the gun violence prevention advocacy group Everytown for Gun Safety estimates that there are 389 gun demises per year in New Mexico, or 18.3 demises per 100,000 residents, making the land of enchantment the 8th highest state for gun demises per capita in the nation.
From 2017 to 2021, 143 children were killed by guns.
But she and the others at the table said despite their differences, they're committed to working together.
Averaging 1,000 or more violent crimes per 100,000.
According to Lujan Grisham's executive order, the rate of gun demises in the state increased by 43% between 2009 and 2018, which is a remarkably larger increase than the 18% increase over the same time period nationwide. Important context. Bipartisan Safer Communities Act, which President Joe Biden signed into law last summer, strengthened gun control measures by, among other things, closing the so-called boyfriend loop that allowed domestic abusers to own guns and by making gun trafficking a federal crime. Domestic lawmakers, Democratic lawmakers, have been pushing a number of bills in recent years that aim to reduce gun violence in the United States. President Joe Biden also issued an executive order in March to tighten background checks for gun dealers. Among other things, the U.S. executive order directed federal organizations to create plans to stop gun dealers with suspended licenses from selling weapons. However, other Democratic-led initiatives to reduce gun violence have fallen short in Congress due to vehement opposition from GOP members. After passing in the House, which was then controlled by Democrats, a bill to outlaw assault weapons failed in the Senate last year due to strong opposition from Republicans who said the bill would violate their Second Amendment rights. In an effort to curb gun violence, many on the right have advocated for legislation that supports mental health and school security. House Speaker Kevin McCarthy said in March, "We've got to deal with mental illness." Controversial gun rights restriction in New Mexico sparks outrage. In New Mexico, a recent decision by Governor Michelle Lujan Grisham to temporarily ban concealed and open carry of firearms in the city of Albuquerque and Bernalillo County has ignited significant controversy and criticism. Critics refer to the governor as a tyrant wannabe and draw parallels between her actions and the British monarchy. They argue that this move infringes upon the Second Amendment rights of citizens in the affected areas and sets a concerning precedent for the future. The supporters of gun rights claim that the ban, enacted during a public health emergency, is a questionable exercise of power. They argue that such measures might open the door to further encroachment on individual liberties during crises. There are concerns that if this decision goes unchallenged, other state governors could be emboldened to take similar actions in the event of future emergencies, such as the return of COVID-19. In response to the ban, some law enforcement officials, including Albuquerque Chief of Police Harold Medina and Sheriff John Allen, have refused to enforce it. They believe that the ban violates citizens' core constitutional rights and have chosen not to participate in its enforcement.
And are likely not to agree with the totality of the first initial steps.
Openly acknowledged she expected fierce opposition to today's announcement, including from the law enforcement leaders.
We have a bunch of resources that we can utilize to make sure that we start making a dent.
Critics of the governor's actions are arguing law enforcement agencies and officers to consider the historical context and implications of the ban. They assert that it's essential for law enforcement to be aware of the potential consequences of supporting such restrictions on the right to bear arms. In conclusion, this contentious decision by Governor Lujan Grisham has sparked a passionate debate about the balance between public safety and individual rights during times of crisis. It remains a topic of significant concern and discussion among citizens and law enforcement agencies in the affected areas. Well guys, that's all for this video, and we'll see you again in the next one.